I'm Faisal Bulbulia and an executive member of AMAL. Welcome to a 1-hour webinar on mediation. Before I introduce the speaker, the agenda will be as follows. We'll start with an opening dua, then my introduction of the speaker, then about a 45-minute talk by our guest speaker, with a 10 minutes, followed by a 10 minutes questions and answers, vote of thanks, and followed by a closing dua or prayer. Mohammed is an expert in the field of mediation and will guide you through the subject of mediation. Mohammed has both a BCom and an LLB degree. He was admitted as a practicing attorney in 1994, the birth of our democracy. Mohammed is a member of the Faculty of Mediation of the Law Society of South Africa, providing training in mediation. He's accredited mediator both locally and internationally. He specializes in civil, commercial, community-based sports mediation, and in particular, family law mediation. I hand you over to Mahomed Essack.
Thank you, Faisal. Assalamu alaikum and good morning to everyone. At the outset, I think just a short dua. A'udhu billahi minash shaitanir rajim. Bismillahir rahmanir rahim. Inna a'ataynaka al-kawsar fasalli li rabbika wanhar inna shani'aka huwal abtar. I would like to thank AMAL at the outset for affording me this opportunity to advocate for mediation, as I often refer to it. I think it's an ideal platform to use webinars. I'm assuming some of you in the comfort of your homes, some perhaps in the offices, but wherever you are, thank you for sharing your time with me. So a big thank you to AMAL, the Association of Muslim Accountants and Lawyers, for facilitating this. And also a thank you to Al Baraka Bank, who is the corporate sponsor for this presentation. So I'd like to begin in the time that we have, which is essentially an hour, to take you through to my presentation. So I think mediation, many of you may already know what it is, but this time that I'm going to spend with you now would probably give all of us broad brushstrokes as to what exactly mediation is. And when we start about talking what mediation is, I often introduce the topic by splitting hairs. I say to people, in life, conflict is natural. Conflict is natural. We cannot avoid conflict. And in order to understand what mediation is, I separate the concept of what a conflict is and what a dispute is. So I would propose to you that conflict is natural and that it happens in all settings. So conflict is inevitable and natural. It permeates at various levels. So whether it is in the confines of your home, whether it's in the workplace, whether it's between strangers, motor vehicle accidents, and occurs, but generally occurs between parties who are already in a relationship. So the opportunity that conflict affords parties to it is the ability then to address the conflict. In other words, if you and I have a conflict, if we have a difference, if we don't have a meeting of minds, we then have an opportunity to find each other and to communicate and to find each other's common ground and to address the difference. Now, if you look at the screen that's up on on your screen, the slide on your screen, you will find types of relationships in which conflict can arise, and I'll start with the one on the top left-hand corner, family. Whether it's between partners, whether it's between husband and wife, whether it's between siblings, right? Many of us are siblings. Many of us are in relationships, okay? Contract. All of these relationships involve people that are already aware of each other's existence. If you look at contract, if we drill down further, You have contracts between landlords and tenants, employees and employers, manufacturers and the parties to whom they supply manufactured goods, wholesalers and retailers, landlords and tenants, something that has come to the fore with full force, after we had the lockdown provisions and so on. Neighbors, this is something we don't look at often, but prior to sectional title development and so on, we lived next to each other in homes, in residences. We would have boundary issues and so on. Things became a lot more complicated when we had sectional title development. Some of you who are legal practitioners or even the non-legal parties to this webinar will know that often we have a conflict between our neighbors, especially within the sectional title realm. Another example where conflict could arise and in relationships within the school or an education setting. So whether it's between, even if you drill further down, between learners themselves, between learners and educators, between educators and educators, between educators and management, between management and the board, between the board and the community and so on. So I'm sure everyone understands that there are so many relationships that we have in our lives, in our daily lives, and that it is bound to happen that conflict will come to the fore. I repeat that conflict gives us the opportunity to find each other, and then to come close together in terms of an understanding and how we are going to address the conflict. Unfortunately, conflict always does not get resolved for a number of reasons. Sometimes there are communication issues. Sometimes there are styles of approaching conflict which are vastly different. You may get a party to a dispute who's robust, who's aggressive. You may get a party to a dispute who's permissive, who's quiet. So you'll find that the ideal outcome will never be sought because there'll always be this disquiet and a sense of imbalance regarding the outcome where the relationships may not necessarily be equal or the approach to addressing the differences are vastly different, and especially where parties are approaching the conflict without any intention of trying to understand or find each other's point of view in terms of, let me cross over the table and see how is this person looking at the situation. So what I say is, when a conflict, when a difference cannot be addressed, it then morphs into a dispute. It morphs into a dispute, and this is when the conflict that initially was there has now morphed into a situation where the parties themselves cannot address it. And from a legal point of view, and this is for the purposes of time, I'll get right into it. You'll find when people cannot resolve their disputes. And if we go back to family, contract, employment, parent, teacher, neighbors, landlord, and tenant, this is the point that they start engaging legal advice. To my legal friends, my colleagues in the legal field, this is the opportunity that you have as a gatekeeper on behalf of your clients, of disputes, to decide what happens next. But before we look at what mediation is and how mediation can help us to address disputes, let's look first at what litigation is in relation to why I am going to propose to you that mediation is an eminently reasonable methodology to approach disputes. So if you look at the last point on this slide, it says the one way of addressing disputes is through litigation. And what is the litigation journey as we know it? To many of my colleagues, this is old hat. Litigation takes time. It lasts a long time, from 18 months to 3 years, sometimes shorter, sometimes longer. What does it entail? Many, many consultations, letter writing, pleadings, formalistic approach, court appearances. Litigation is acrimonious. No one can dispute that, can you? Litigation is costly. To some of you who have been party to litigation, costs a lot of money, time consuming. In litigation, the outcome is in the hands of a third party. Disputants take their problem or the dispute that has arisen, hand it to their attorney, and the attorneys thereafter present cases to a magistrate or a judge, who will then decide based on credibility and evidence as to who the winner or the loser should be. One important point, colleagues, when we initiate and when we institute legal proceedings, and if you look at the first point of my slide, we would say it lasts from 18 months to 3 years. By the time a matter gets to the ears of a magistrate or judge, I kid you not, but many of your clients' positions, as pleaded in your pleadings at the start of the proceedings, your clients' positions, your clients' circumstances have now changed 18 months to 3 years later, isn't it? So, winner and loser type of context, obviously, always not the ideal, especially if you had to track back to one of the slides that I made reference to earlier, that disputes arise between people who are by and large in relationships. Does it help at all for people who want, even at some level, for the relationships to endure, to have an outcome where one is declared a winner and one is declared a loser? How will that help for a relationship to endure? How will a cost order help for a relationship to endure? If I was in a dispute with Faisal Bulbulya and that matter went to court and Faisal was the victor and he was awarded costs in his favor against me, what would that do to my relationship with Faisal? Now ask yourselves, is litigation the ideal way of dealing with disputes? Let's go further. In pleadings, when it comes to litigation, and especially in family matters, allegations are of an accusatory nature. They are maligning and disparaging of parties. Classically, and many of my legal colleagues will nod their heads and say, this is again old hat. The defendant has failed to treat the plaintiff in a manner befitting a wife or a husband. And this old classic, the defendant makes the plaintiff's life miserable and intolerable. What do you think will come back in a plea or a counterclaim? Allegations thrown back to the other party, either in the same vein or even in a richer vein. So this sort of thing carries on. When we look at litigation and we look at the language that is involved in litigation and the robustness and the aggression of litigation, it is not unheard of for us as legal eagles to say things like, don't worry, we'll punch holes in their legal argument. We are armed with sufficient facts to shoot down their arguments. Our counsel's argument will blow them out of the water. Now, I am not saying that there is no place for litigation. This is a presentation to make a case for mediation. And in a separate presentation, perhaps, we can address when litigation is inevitable and it is absolutely imperative. But for now, I'm trying to guide you towards a better way to addressing disputes. When it comes to family law, and I often say this, the case against litigation is the time that it takes to wait on experts, psychoforensic reports, waiting on the family advocate to conduct interviews, to provide recommendations. These result in extensive delays to the litigation. Whilst we may say we will wait it out, but think about the effect it has on the parties to the proceedings, on their psyche, on the cost factor, on children who are waiting to get back to some sort of normality. If you look at litigation, communication is formal, and often the parties, and especially in family law, including the children, those voices all get sideshowed. They all get shunned to the side because it's attorneys now communicating with each other either through correspondence or pleadings in a very formal way without necessarily the nuances and the tones of the parties themselves, and especially the children coming to the fore. Okay? This is something I feel very, very strongly about, that relationships between the parties then become strained. I track back to an earlier slide where I said to you that disputes by and large are between parties who are already in a relationship. We as a society, we as a legal fraternity, we as community leaders, or even the head of a family, mums, dads, or workplace colleagues, we have a duty to create a society which is cohesive. And I'm saying to you that fighting with each other, looking for a result where we have a winner and a loser, finding a result where I'm going to hang you with a cost order, does that help in our relationships? It doesn't. Because at the end of the day, whether it's a civil or commercial relationship, or whether it's a family relationship, a business partnership, those are enduring relationships at some level or the other. So having cost orders and winners and losers doesn't assist relationships. Okay, as I say in the slide, relationships become strained and even severed. Families, business partners, civil and commercial matters where parties have long-standing relationships, right? Another issue, insofar as I'm concerned, against the case for litigation is the lack of suitably experienced attorneys or advocates who may necessarily have the expertise to deal with the matter. Now, I say this in a very qualified way, because as attorneys, me included, certainly we have a duty to clients to do a risk assessment at the outset of the matter, not a month before the trial. Am I acting in a manner that is in my client's interest? Will I save my client money? Will I help my client to get a result which is reasonable and suitable to my client? Okay? And whatever the outcome, or whatever the process or the methodology that I'm going to suggest to my client, is this what is in my client's best interest? Is this what will help his or her or the entity's relationship with the other party? These are things that we certainly need to take into account. So colleagues, with the greatest of respect, we have eminently qualified counsel, attorneys, legal advisors to whose expertise we differ. But I'm saying pause. Look at a new way. Let me rephrase that, not a new way. Look at something different. Look at your client and look at the methodology that you're now going to implement to help your client. And do this risk assessment and ask yourself, will litigation assist or will mediation assist? And I'm coming to mediation where I'll drill down further. Okay, what is mediation? A very short type of definition by Newpin. It's a confidential process in which parties in conflict enlist the services of a neutral third party to assist them in reaching an agreement on contested issues. Just something for us to look forward to is a definition of what mediation is. And I've made this as broad as possible. So instead of using classical definitions of mediation, I've attempted to sort of get us into a definition mode where we're looking at all of the nuances of what mediation is. Number one, it's voluntary. So in other words, it's a process where we submit to without being coerced. Okay? It's something that comes naturally, perhaps, that I'd like to sort out my problems. If we look back in the day, the cliche that let's sit around a table. People came around the table. It was voluntary. Unlike litigation where you don't have a choice. If you served with a summons or an application, you're now locked into litigation. Mediation is a process that takes place without prejudice. Unlike court, unlike litigation, where pleadings record your position in the matter, where whatever you say in court is recorded and transcripts may be obtained later. So whatever you say, you're on guard. when we say mediation is without prejudice, we are saying to you people that it affords you and your clients, parties to disputes, to speak freely, to speak in a protected environment. Because at a mediation, we are saying to you, we are affording you the opportunity not just to talk about your positions, but it's to talk about your interests. And obviously, my pet subject is family law. I often say to parties that when we are in a mediation, as I was in yesterday with parties, that when we're looking at interests, we're not just looking at the interests of the adults, we're looking at the interests of children. Okay? So this process allows us to look not just at our positional situations and as we've pleaded it in pleadings, but it allows us to ventilate what our interests are. You know, in family law, in divorce law, anything to do with children, separation, maintenance, domestic violence involves a lot of emotions. I challenge any of my legal colleagues, can you plead emotions in a pleading? Can you plead emotions in a summons, in a counterclaim? Your clients are not speaking, it is you who are speaking on behalf of your client. Can you say in the summons, my client is angry, my client is hurt, my client resents his or her partner, my client is sad, the children miss their father. Can dad in his counterclaim say that his children miss him when he speaks to them? You don't get that in a pleading. He's going to say it's in the best interest of the minor children that he has contact with the children. So when we are at a mediation, when we speak to the parties, we are drilling further down to find out what exactly is within their thought process and what is it that they want to say. A mediation is not a process that results in the adjudication of the matter. So when we go on to the next slides, you'll see the role of the mediator is to be neutral. So it's not the duty of the mediator to make findings on credibility. It's not the duty of the mediator to find out who's wrong and who's right, who should be awarded X and who should be awarded Y. It's not. That's for litigation. Mediation is a safe space for the parties to sit down with the mediator, who I repeat ad nauseum, is neutral. So it's not there to make a finding, and the neutrality of the mediator is so important to the process. Why is that, colleagues? You as the mediator, and some of you may be mediators, some of you may have designs on training in mediation, and some of you may not. But the point is, when the mediator sits with the parties, it is the duty of the mediator to engender a relationship of trust between the parties, so that when the mediator sits with the parties, they will speak freely to him or her, okay? We cannot have a situation where if information is disclosed at a mediation, that such information then can be used at court. So again, eminently reasonable. If we're discussing matters in a mediation within the confines of the process, whatever is said, whatever documentation is provided, is all private and confidential and used specifically for the purposes of the mediation, except those documents that may have already been discovered or may already form part of legal proceedings pending between the parties. You will not disagree with me, I'm sure, if I say to you, listen guys, come to a mediation, whatever you say is private, confidential, can't leave the room, I cannot be subpoenaed to court as a mediator. It affords you a very, very good opportunity to come and lay your cards on the table, both parties. A mediation focuses on what's going to happen in the future. What's the solution? I pointed out to you earlier that when we look at pleadings and litigation, we're looking at positions at the start of the proceedings. 18 months to 3 years later, things have changed. So at a mediation, indeed, what has happened in the past is relevant. It affects how we feel, it affects how we see life as it is, but it also focuses on a solution-oriented process. How is it that the mediator with the parties, okay, can find a solution? I reiterate that mediation is non-judgmental. And to mediators out there, and I remind myself first, we are not there to judge parties. A mediator, irrespective of how he or she sees life, has to treat the parties in an absolutely neutral way. I often joke, whether you support Kaiser Chiefs and one of the parties to the mediation supports Orlando Pirates, you're not going to treat them differently. Okay? You have to be non-judgmental. You cannot judge parties on the way they appear, on the way they speak, on the way they look. We all are sitting before the devices we have when we are watching this webinar. We have all walked different paths in life, right? My path started on the 11th of June, 1968, when I was born in Newcastle. Your path may be some other way. You may have I schooled in Newcastle. You may have schooled in Joburg, someone in Cape Town. We had different life experiences, okay? So as we sit where we are now, we have all come from different paths. But the trick here with mediation is that when the mediator sits with the parties, he does not judge the parties. He does not look at the parties through his or her life experiences. And I often do this through your eyes or your rose-tinted glasses. You look at the parties as they are. Mediation enhances communication between the parties. Often, and when we go back, if you can remember some of the earlier slides, when litigation starts, the communication is now formal. It's letter writing and it's pleadings. What happens with mediation is that after a long time, especially when litigation has started, the parties are now sitting together in a safe environment where they are actually communicating. Give you a classic example. Parties may have been married, they are still married, they were separated 6 months ago for whatever reason. They've wandered off to attorneys, and the attorneys now are exchanging copious correspondence and pleadings, but they haven't spoken between the two of them for the last 6 months. They're spending money, and as I said, the communication is formal. When the matter comes to mediation, it enhances communication between the parties. They are sitting together with the mediator, who at this point, I may say to you, it will come in the later slide, but perhaps now is an opportune moment, is that when the mediator sits between the parties or with the parties, that process belongs to the mediator. The mediator controls the process. Our aim is to control what happens in the process, to create avenues of communication, to create avenues of identifying issues, to create avenues of finding and seeking solutions and so on. The onus is on the parties to find the outcome, to find something that is suitable to both of them. So when the parties sit at a mediation, they haven't communicated after a long time. Same with civil and commercial matters. So when we allow this environment for the parties to communicate, it obviously will help to build relationships to the extent that the parties need to have a relationship. If you look at family law, people may cease to be husbands and wives to each other, but they'll always be parents to their children, whether baby is 14 or 15 months, or whether it's a teenager who's 15 years old. Those two individuals will always be parents, all right? The outcome of it's the outcome of the process is in the hands of the parties. And what is that? It's the solution. What is it that will be suitable to the two parties? And again, whether it's civil and commercial or whether it's family law, they, together with the mediator, will go through this process where at the end, the parties themselves will say, okay, I may not have got what I wanted at the outset, but I can certainly live with this outcome. How does that help? They've saved a lot of money. There's no cost orders. There's no winners and losers. And importantly, if you look at the next point, the parties will feel empowered. Why? They are more likely to comply with their own agreements, isn't it? The neutrality of the process and the environment that's created by the mediator obviously creates an atmosphere for the parties to discuss issues. An important process or part of the process of mediation is that the mediator can communicate with the parties separately. I often use this caucusing technique between the parties where, for example, the relationships may be unequal. Okay, and that is up to the mediator to dictate the process of the mediation. And it's one of the most useful tools that we use in mediation, side caucusing. So it allows us, and importantly, the party to the mediation, whether it's civil and commercial or whether it's family law, to talk to the mediator freely without feeling intimidated by the other party because they're not in attendance during the side caucus or where the mediator speaks separately with the party. Obviously, mediation is less time consuming. Lawyers, advocates, how long does it take to get a trial date? Even with the courts functioning the way they are, stop, start, and so on. It takes a long time. It's very formal, it's very procedural to get your matter to court, to get a judge or a magistrate to hear your matter. How long does it take to convene a mediation, you may ask? If you get to a mediator by phone or by email, Mr. Mediator or Miss Mediator, I have a matter, I'd like to refer that to you. When are you available? I am sitting by myself here. There's approximately 56 of you on the other side. Okay? We're using technology. When people or parties or attorneys call a mediator, all the mediator does is have a look at their diary. And you'll find availability either later this week, if it's at the beginning of the week, or next week, or the week after. That's not 18 months and 3 years. That's pretty soon. Okay? It's less costly. Mediation doesn't cost as much as litigation. Generally, in the mediations that we do and mediation agreements that are signed by the parties before the mediation commences, the parties agree to share in the cost of the mediator. Can anyone argue with the reasonableness of that? The mediator is not a hired gun, not inclined to either party's cases. The mediator is unaffiliated to both parties. The parties are contributing towards the cost of the mediator in equal shares, fair and square. Here's an important point about mediation. It's informal. How many of you lawyers fondly remember your first or second or third appearance ever in a court of law? Even recently. How many of you have actually done trials, lawyers? I'm sure many of you have. Some of you have not. I mean, it's not uncommon now to ask a qualified attorney, have you ever done a trial? And he'd say no, or she'll say no. Imagine how intimidating it is for a party to a dispute to appear in open court when we sometimes as attorneys also have anxiety about appearing in court. People in court are dressed formally. Everyone's looking up to a judge or magistrate. The language is formal. The decor is formal. It's very intimidating. Imagine for a first-time litigant who's taking a chance with you, on your expertise. You've obviously advised them on the merits of the matter. Spending money that sometimes they do not have, where they are borrowing, etc. Some litigants do have access to resources. That's a separate topic in its entirety. But the point here is that mediation is informal. It's informal. You don't have to have a tie. You don't have to wear a blazer. You don't have to be in a formal setting. We can sit around a table. I've done mediations with parties at a coffee shop, using a room at a hotel, a function, a sort of conference room, walking on the promenade. It's organic, it's informal. As a mediator, our role is to get the parties to identify issues, to feel comfortable, to be able to talk, to be able to express, to let the process be cathartic, for them to move from here to there, identifying the issues, and then finding common ground where they can then move forward. Okay? Promoting access to justice for more disadvantaged people, or people who may not have financial resources to litigate. Okay? access to justice is expensive. The outcome of that process or that entire court proceedings is uncertain. So when people who are not of means have available to them this sort of process where their disputes, their interests are heard, and through the assistance of a mediator, the parties are sort of assisted to get to a point where they can find common ground, not entirely what they may have set out to get, but at least something that they can live with, then you've done very well. Okay? Mediation, if it's unsuccessful, may at least narrow issues that need ventilation at a later stage. So in other words, if there were 5 issues that were, or there were 5 disputes, at least 3 or 4 could have been resolved and 1 matter could have been taken to trial. That's not unreasonable. Okay, I'm watching the clock and I'm watching my slides at the same time. The mediator, you have to be neutral. I spoke about being judgmental. I spoke about the paths that we take in life to get where we are. And I want you as a mediator or a prospective mediator or a party to a dispute to also understand where the parties to the disputes have traversed. How did they get to the position they are? So the mediator controls the process. That process is the mediators. So we'll welcome you to the mediation. We'll put you at ease. We may offer you a cup of coffee or tea. We'll tell you that all of this is without prejudice. There's no recordings. We don't allow cell phones and devices to record whatever happens there. You are safe in this space, okay? Let us help you to identify what issues there are. We'll create the environment for you to communicate by using the various techniques that we learn through courses that we attend and through our experience and watching our mentors and learning as we go along. We create an environment for the parties to communicate freely. You will remember early on I spoke about emotions, anger, resentment, sadness, being weepy, and so on. This is what all unfolds at a mediation. And as the mediator, we do our best to create that environment so that people feel that they are being heard. Okay? And we continuously draw lines in the sand and say, okay, we've dealt with this. I understand how you feel. The other party may not agree, okay, to a dispute, but now what's the next step? What's the next step? And like this, we move forward to try and assist the parties to finding a solution that is reasonable and acceptable to both of them. Mediation facilitates settlement. It facilitates consensus. May not facilitate a final outcome of the matter, but sometimes facilitates a settlement in terms of which we will agree. If this pen was not manufactured according to the specs that I asked the manufacturer to do so, and there's a dispute regarding that, if the matter went to mediation, and it's a simple example, the outcome of the mediation would be to refer this pen to Faisal Bulbulia, who's an expert pen maker, to say, can you pronounce on whether this was done properly or not? And that could be the outcome of the settlement, that whatever Bulbulia says, that is what we'll abide by. When can mediation be an option? People, it can be an option before or during or after legal proceedings are instituted. Obviously before a judge or a magistrate has pronounced, that's an obvious one. But mediation can take place at any time. I'm not going to go into the Rule 41A that is now available in terms of high court proceedings, and I will approach AMAL to host a separate webinar on that provision of the Act. But certainly mediation can take place at any time. Mediation works, guys. It really does. It really, really does. It's practical and it's effective. Ask yourself, colleagues, lawyers, when your client comes to you, you have to look at the dispute that they have. And I did a separate seminar for the University of the Northwest previously on attorneys, lawyers, and gatekeepers of disputes. We have to look very let me rephrase that. We have to hyper-focus on what is in the interest of our clients. Is it in their interest to litigate? Is it in their interest for this dispute to go on forever and a day? Let me look. What are the options? My client is sitting before me. I've listened to all of what he or she has to say, whether he or she is a captain of industry or someone going through the throes of a divorce or someone who has a dispute with their soccer club, right? And I'm putting it to you, consider mediation. It helps relationships. Faisal, I see you. It helps children, right? When we mediate, the outcomes generally are a win-win situation. And I repeat, it's not as if you will get what you set out for at the beginning of the matter, but it's certainly something that you would aspire towards in terms of what can I live with? I can live with this. I'm prepared to move on. I've saved money. I've saved a relationship to an extent. And in civil and commercial relationships, often those relationships need to be repaired. And litigation is not going to help that, but mediation will help that. Okay? So, as I say, the ideal situation will be for both parties to walk away with something they can live with. A quote by Madiba, negotiated solutions can be found even to conflicts that come to seem intractable, and such solutions emerge when those who have been divided reach out to find common ground. I'm going to stop sharing the slides, but that in essence is in broad brushstrokes what I have to say about mediation. Faisal, over to you. I'll be happy to take some questions. Can I go through the questions, Faisal?
Hi, Mohammed. I don't know whether you can look at the questions, but
I can. Can I just squish through them?
Yeah, I just want to inform you that I'm impressed with how informed all our attendees are for this webinar. The question is, who pays for the mediator's costs, especially in cases where one party is poor and the other is rich, and the poor person is claiming his rights from the other?
That's an excellent question. And again, this is a point I remind myself, as well as other mediators out there. To the party who asked the question, thank you very much for that question. You may find sometimes that one of the parties cannot afford to contribute at all to the cost of the mediator. But again, and I don't want it to sound utopic, but the beauty of mediation, and especially if the mediation is in the hands, if the process is in the hands of a mediator who is credible, who is neutral, irrespective of who pays the mediator, both parties, and I'll answer the question towards the end of this, both parties will feel that the process is credible. So if one cannot afford and the other can afford because they are rich, then that person will pay, but the party who cannot contribute will be rest assured in word and deed and the conduct of the mediator that that process is completely neutral, and that notwithstanding that only one party is paying, and the other party is not paying, that the process will be compromised. That will not happen.
Okay, the next question, Mohammed, is how does one choose or appoint a mediator? Would it depend on the type of dispute, or must the mediator have knowledge and understanding of the item or thing in dispute?
That's another excellent question. So you're looking for a mediator who is approachable, who is going to create an environment for the parties to speak freely, and who's credible. A mediator is not to play one against the other. An important point that I picked out of the question, especially in subject matter, is it necessary for the mediator to have some knowledge of the subject matter? I would say yes. So you'll find mediators that are very au fait in mediation insofar as family law is concerned. Some are au fait in commercial and civil. Some are au fait in sports mediation. Some are au fait in construction mediation. So like you will find lawyers, you get general practitioners, you'll get mediators who can generally practice across the board. But you'll also find mediators who are practicing in niche areas. So I think if you look, and again, I'm going to add this on here in terms of how do you find a mediator? Your mediator should be accredited by an organization or a body who itself is credible, that at least your mediator, the accreditation of your mediator meets South African quality assurance standards. There are organizations to which mediators are affiliated. You could go onto websites of mediation organizations and you could tease from there mediators that will sort of fit the dispute that you want to have mediated. Often you will find attorneys, advocates, are also trained mediators, and those that are not will know mediators who are au fait with the topic or the subject matter at hand.
Okay, Mohammed, the next question. Thank you, Mohammed, for enlightening us on a real win-win situation. Type of solution. If one party renegates on a mediated settlement, should the agreed settlement be in writing, court order, or commission of oaths?
Excellent. Thanks for raising that. So what is the outcome? And I think for 45 minutes, the questions sort of help to complete the presentation. So at the end of the mediation process, assuming now we're successful, we have an outcome that both parties are happy to live with. It doesn't stop there. We need now to commit the terms of the settlement into a settlement agreement. So the agreement then records the outcome of the mediation. And that agreement is now a settlement agreement. It's concluded upon signature Faisal of the parties. It can be made an order of court. If proceedings have already been instituted, your attorneys will know what to do with that settlement agreement. But assuming now, the preamble to your question, what happens if a party backtracks, breaches one of the terms of an outcome which was committed to in writing and signed by the parties out of a mediation process? What we as mediators do, that if a breach occurs, we include within the settlement agreement a clause that provides for further mediation. So if a clause is breached, we will say to the parties in the agreement, or the parties would have agreed to this in the mediation process at the outcome, that if there's a breach of the settlement agreement, that breach or that dispute will be referred to mediation. If at mediation that cannot be resolved, then the parties, as is their constitutional right, can approach the courts of law. Shamima Hussain, can mediations be held remotely? Yes, they can. They can be held. I can conduct a mediation from here with one of the parties in Newcastle and the other party in Danhausen. Okay, this is what's
Mohammed,
happening. It's
Mohammed, two questions, but it follows each other. What's the difference between mediation and arbitration? And is arbitration a better process in solving a dispute rather than mediation?
Okay, simply put, in my view, and a very lay sort of definition regarding the differences, mediation, I've explained to you, it's without prejudice, it's off the record, it's until there's a conclusion between the parties in writing and settlement. It's non-judgmental, there's no evidence, there's no credibility findings, etc. Simply put, I would look at arbitration as private litigation. So there is a difference. On the arbitration side, it's held in a venue other than a court. But yes, there's a winner and a loser. Yes, there's often a cost order. Yes, there's evidence. Yes, there's findings on credibility, right? Yes, everything that is said is with prejudice. Things are recorded. So there is a difference. The methodologies are different. Arbitration would follow more on the litigation side, except litigation, you're not paying for the judge, you're not paying for the courthouse, you're not paying for the stenographer, you're not paying for the judgment. In arbitration, you're paying, and you will pay for the award. Mediation, as I've explained in terms of the difference between mediation and litigation, the differences are often the same, if not substantially similar, between mediation and arbitration. I hope that answers that question.
Okay, Mohammed.
And the other part, the second one?
No, the difference you've said.
Which is better?
Arbitration or mediation, as you've explained to us, the difference. Just
mediation. I'd go for mediation.
Okay. How can we assess neutrality of the mediator? How do you handle the hostility between parties at the outset of the mediation? And what is the cost structure of the mediation process?
Neutrality. How do you assess the neutrality of a mediator? So when we train, when we sit with the parties, and that would be possibly another webinar, right? We as mediators have to conduct ourselves, and parties to mediation must feel confident that Mahomed Essack is giving Faisal Bulbulia sufficient airtime and giving Zain Fakhruddin sufficient airtime. So I'm moving between the parties. They must feel as if I'm treating them fairly. If I have two parties to a mediation and I allow one party to speak only, or even when both parties are speaking, and my relation with them and the way I relate to them is different, certainly one is going to feel aggrieved, one is going to feel, but this fellow is taking sides. I don't feel comfortable in this process. Dealing with hostility, again, these are techniques that as mediators we will use. If there's a lot of hostility, if it's very acrimonious, I've conducted mediations substantially with the parties apart. Caucus mediation, where I didn't have them in the room throughout the mediation and maybe towards the end. All right? There are techniques we use where we rephrase, we reframe. Okay? We tell someone, if someone says to me, Faisal, in a mediation, I'm angry, he's an absolute idiot, I would wring his neck. I would rephrase that and deal with that anger and perhaps say, Faisal, I can see you very upset with Zain, aren't you? See, these are the techniques that come out, but we have to allow the parties that opportunity, because then it becomes more cathartic, it becomes more beneficial to them to move forward. And when we move forward, then we can start seeing our way to finding solutions.
Okay.
The cost structure, the last one, Faisal, someone asked about cost. The cost structure, generally mediators will charge per hour. And again, it will determine, it depends on the experience and complexity, you know, the years of experience of the mediator and so on.
Okay, doing a 40-hour mediation course by an accredited mediation organization is one, and then a mediator.
$1 million question. Okay, so it's like going for tennis lessons and not playing tennis. So you can go for a 40-hour mediation course, but the meat of the matter, many of the 40-hour mediation course will be theory and then fishbowl experience. But I think often colleagues and mediators, we don't get experience after we train. We need to do mediations because that's where the meat is. That is what you have to do. That's what you've trained. And it's the bane of many trained mediators who have done the 40-hour courses. And I say to them, do not despair, do not lose hope. Pair with other mediators who are already getting mediation work and ask the parties whether you can sit in. Get involved in situations where you can co-mediate, right? And I think also as AMAL or as an organized body, we must also look at webinars where we can assist mediators to market their mediation practices and market themselves. But I agree, there are 40 hours will equip you with skills, but you need to put those skills into use. Remember, when you are doing a real mediation, you have the lives, the futures of parties in that process which you are controlling.
Okay, Mohammed, how do you promote the mediation process where one party does not wish to enter into the process?
Excellent question. I would ask that party, what's your option? What's your best alternative to a negotiated outcome? Are you willing to spend hundreds of thousands of rands? Are you willing to leave the outcome of the matter in the hands of a judge or a magistrate, which outcome is uncertain? Are you certain that when a judgment or an award is made, that would be the end of the matter? Are you aware of appeal procedures that could be instituted after the judgment is given? So Faisal, these type of reality tests with parties to say, what is your alternative to mediation? So if you ask me, how do we get parties to come to a mediation? I think as attorneys, we need to advocate it because we're acting in the interest of our clients. We as attorneys should say to clients, You are better off sitting at your desk at work, or in your retail store, or in your wholesale, or in your manufacturing business, rather than sitting in court. And here's an opportunity. And you can tell your clients that, yes, it may be a bad business decision from a litigation point of view, but I, as your attorney, I'm looking after your interests. So you can convince people. I think attorneys have a lot of power. And again, I repeat, we are the gatekeepers of disputes. And a lot of what we say and do will determine whether our clients will go for mediation or not.
Okay, thanks, Mohammed. I think we just got 4 minutes left. I wish to thank you, Mohammed. There's been excellent questions. I want to commend all the attendees for this seminar. Thank you, Mohammed, for an excellent and informative presentation on mediation. I'm sure it will go a long way in informing you attendees about the effective alternative dispute resolution option. I wish to also thank Al Baraka Bank, a major sponsor of AMAL, and the executive of AMAL, and Farzana from AMAL for organizing this event, as well as all the other attendees. And then AMAL was established in 1984. And for more information on AMAL or to join AMAL, please visit our website. You know, to join AMAL, it just costs 100 Rand. And I think this seminar cost, if you look at it, you get, it's actually much more. So please join AMAL. We have many more webinars in future, and we had in the past had a lot of webinars. Our next AMAL's joint webinar is going to be on corporate governance for Islamic NPOs, and it is scheduled for this afternoon at 3 o'clock. So please join in. Okay. Let me just make the closing dua, and then.
Thank you, Faisal. I appreciate the opportunity. And we pray to Almighty God for our protection, for that of our families. We pray to God for giving cure to all of our loved ones who may be sick or who are ailing, and those that have passed on, to grant them the highest stages of Jannatul Firdaus and grant their families patience. With that, Jazakallah Faisal. Assalamu alaikum, and what is it? Good morning still. 11 o'clock. Thanks, guys.
Right. Okay, thank you for attending the seminar. Thank you very much. Salam.